Trustees, and today we'll be talking about estate planning. Now, estate planning is one topic that, one very sensitive topic that people do not like to talk about. And that's because of, it actually talks about one's demise, transferring your assets somehow after one's demise. But it's essential, that we talk about how to transfer our assets after we pass on. And as we go on in this webinar, we'll see the reason why it is very important. So today's topic, we're going to cover an array of subtopics. We'll talk about what is estate planning. We'll also highlight some life stories, some good, some bad. We'll talk about how the effects of passing without a will or without an estate plan. We'll talk about some advantages and of course the disadvantages that occur. We'll also talk about some estate planning tools, particularly wills and trusts, and then we talk about the services and also wrap it up with how you can reach us after this seminar, or after this webinar rather. There's a Q&A box just at the bottom of your screen. Please, you can drop your questions in that Q&A box, and we'll try as best as we can to answer some of those questions during the webinar. Otherwise, we'll get back to you with the answers after the webinar. So we'll just get right into it. What is estate planning? It's essentially, the process of how one can transfer his assets, his wealth, his or her assets or wealth during one's lifetime and even after the person's death. Now, you would say estate planning, there are some misconceptions about estate planning. Some would say it's only the wealthy, that can pass his or her assets to his or her beneficiaries. Some would also say, since estate planning is just real estate, but those are just misconceptions. Not only the wealthy can pass his assets. If you own a phone, you own a car, you own a TV, you have money in the bank, you have pension funds in your RSA account, and as we go on, we'll see how it just, for pension funds, you can only pass or it can only devolve to your beneficiaries, through a will, which is one of the estate planning tools we'll talk about. So you can have any of those assets. You don't have to be extremely wealthy. You don't have to have millions in your bank. Just one or two items you can all pass it through an estate plan. Any assets at all can be subject of, you can be part of your real estate. Like I said, it could be your car. For women, it could be your jewelry. It could be your investments, your investments accounts. It could be any personal possession that you have can be can make up part of your estate. So like I said, there are actually some advantages in having an estate plan. Number one, you have the flexibility of choosing who you can name as your beneficiaries. Unlike when you pass on, sometimes when you pass on, your estate can fall in the hands of people you don't even like, quote and unquote, maybe your village people that you don't like can own part of your assets. But when you're alive, you can name who your beneficiaries are. It could be probably the children of your deceased friend who you has helped you a lot in the past, and you say, okay, I'm going to pay this guy back by funding the education of his children. But if you pass on, that cannot happen because, of course, you did not take out the time to have an estate plan. Again, you could see how your assets are managed even during your lifetime, particularly when you create a plan that would devolve, that would be managed while you're alive. So you could tell how your beneficiaries would manage your assets, and you could see if someone is managing it well. You can give your assets to probably your brother, and you see that every night is going to the club and you're just wasting your wealth. So in that case, you could say, okay, since this guy cannot manage these assets properly, I'll probably create a trust around it and make a periodic payment such that he gets these monies on a timely basis, and he would not be able to squander, and the assets or the wealth are properly managed. Again, it's a very seamless way of devolving your assets to your beneficiaries. And of course, so get to know later, it's not as costly as when you die intestate. That's when you die without a will and your estate is administered in accordance with state law. In that case, a good chunk of your assets is given to the state in the event your beneficiaries want to procure a letter of administration, etc. So now we'll go to the good stories, the life stories. It starts with the bad. A good chunk of us know Aretha Franklin. She's a multiple award winner. She was the first woman to be inducted in the Rock and Roll Hall of Fame. She sold over 75 million copies of her album. And at the demise, she left about $80 million in her estate. She equally left two handwritten wills that were not executed and did not properly, itemize how her assets would be transferred. And she left more than 7.8 million unpaid income taxes. She left debt. As well, her two sons, her four sons or her kids had this very big tussle, and dirty family secrets were laid out in the open. And this is all because she did not have a fine-tuned estate plan. Kobe Bryant, he died in 2020, just at the onset of the COVID-19 pandemic. He had about 600 million worth of assets when he died. He's a renowned basketballer, American basketballer. Unlike Aretha Franklin, he had some sort of estate plan. He had the testament, he had the trust. Unfortunately, that trust wasn't updated to include his 7-month-old daughter, and that he had at the point of time of his death. And again, later on, we'll see the importance of, even when you have an estate plan, there's the need to constantly update it so that it will include new assets that you procure, or even beneficiaries that you want to add to the estate plan. So bringing it back home, we have Dr. Abiodun Laja. She's the CEO and founder of the renowned Lekki British International School. She died in 2019 at 69. Unfortunately, again, she had no estate plan. So her two sons are in courts, or were in courts, and there was this big tussle over who would manage her assets, particularly, management of the school and the revenues derived from, the school. And this ugly tussle also affected their own immediate family members. So we talk about the good. Whitney Houston comes into focus. Of course, she's a renowned American singer and actress. She's a multiple award winner. In fact, I think she has the most awards, musical awards, female musical awards. She died in 2009, I think, and she left an assets of about 20 million. Before her death, she had about 415 career awards. She had a will, and she named her daughter, her only child and daughter, as the sole beneficiary. She created a testamentary trust around it that, gives the daughter, distribute assets from her estate to the daughter on milestone basis. Again, coming back when we talk about Gani Fawemi, he's a renowned lawyer, politician, human rights activist. He has so many awards, both local and international, on the back of his human rights activism. He died in 2009. He had, of course, about 2 wives. He had 2 wives and about 15 children. He had a will, and he created a testamentary trust in the will that distributes assets in his estate to his family and the poor and the media around, on milestone basis. And I think that is still being adhered or still being done up until now. So what is the effect of passing with a will? I talked about some of the benefits of having a will, or having an estate plan rather. And this is, it helps you manage or create or see that your assets are distributed in accordance to your wishes. You have the discretion of giving access to whoever, unlike when you die intestate, that's without a will, and whosoever comes and claims as part of your estate. Again, in addition to that, sometimes you don't want certain people to inherit under your will, but under your estate when you die. But that cannot happen if you don't have an estate plan, because all any Tom, Dick, and Harry could just pop out to say, I'm his first son, I'm his child, I'm his wife, and I had a son for him, I had a child for him, I had a daughter for him, and they'll all be claiming on that, the estate. But once you have an estate plan, it helps you have a seamless process of transferring your assets to named beneficiary. Again, without an estate plan, it leaves your assets to the discretion of the court, and sometimes, at the custom, depending on, if you're married, depending on the form of marriage you conduct, and of course, state laws. And I've explained earlier that, a percentage of your assets goes to the state in the event that your family or the beneficiaries under your estate to want to procure a letter of administration. So having a estate plan allows you the freedom to choose who you want to, allows you to see how your assets are managed. It's less cumbersome. It's less. It's very seamless. And then it's. I mean, you have peace of mind, if I can say that. At your demise. So I mean, there won't be any rancor or fight or tussle amongst your beneficiaries because you have a good estate plan. So my colleague Eboluwa Tugogo would take us through the next slides, and he'll be looking at wills in focus. Eboluwa.
Yes, thank you very much, Rita, for that insightful introduction. Just as my colleague Rita said, having an estate plan cannot be overemphasized, really, because we've got to understand that in this part of the world, in this part of Africa, we tend to, attribute some sort of superstitious beliefs towards having a will. You go on the street, you hear people say, "Oh, I don't want to talk about my wills because I don't want to die now, or I'm not planning my death, so why am I giving the will?" The purpose of this section of the webinar is to allay your fears and to let you understand, the importance of a will, because you as an individual that has assets, you as an individual that has a retirement savings account, you cannot do without a will. So basically, a will is basically a legal document that describes, how you want your asset to be distributed at the end of your life. Most of us understand, the basic principle of what a will is, but just, the will goes beyond you just having something on paper and then, saying you give this to this, you give this to this, because a will ensures that, you can decide, who or what your property should have, and sorry, yeah. So it will basically gives you the ability to know who you want to give your assets to. It allows you to have a proper record of what you own, and then there's also a full and proper consideration of how your dependents are going to be provided for at the time of your death. And also, having a will, contrary to what most of us tend to believe in, it gives us this peace of mind knowing that our fears are being taken off. The beneficiaries that we have, will be taken taken good care of, at the point of our own demise. There's a lot of reasons why, in addition to what I said, superstitious belief, why people do not want to have the will, and that takes us to the first point that we see here, self-denial. Some of us, we have this notion that, oh, I have a very good, loving family. Nobody will fight over my assets. Everybody's in one accord. Everybody's doing what they're supposed to do. But, I can actually tell you today that most often than not, you get to see even families that are very close-knitted having to, quarrel over their estates because of whoever was the benefactor did not leave a will behind. And that takes me to a particular scenario that I got to experience, at the time in my career with the client. And, we told him, I explained to him, I said, see, you need to put your estate plan in place. You need to have a will. And, he was of the opinion that I have a child, a son, is very loyal to me, he's all of this, all of that. We make sure that my family is taken care of. And as you may have it, this man actually fell sick. He had a cardiac arrest at some point, and his son was with him. So he then, collapsed, and his son that was with him, rather than, pick up the phone and call the doctor to actually, come and treat the father, the son actually called the lawyer and said, "Oh, father," and he told the lawyer, "See, Papa is on the floor. He's already dying. What are we going to do about his properties?" And yes, this is a true life story that happened. And, God will have it, the father got whole again, and then he was able to, come to us the next time and said, "See, I want to put my estate plan in place. This is what I've experienced, and this is what I'm going through that I could not believe." And this, in addition to many things that we tend to see in the society today, are the things that we see when people do not put an estate plan. Also, time constraints. You may want to say that, oh, I don't have enough time. I'm a 9 to 5. I'm busy from Monday to Friday. What will I sit down to draft my will? That is not enough excuse for us not to ensure that our assets are safe. Confidential reasons. So people think, oh, why will I sit down in front of a total stranger and then just be telling the total stranger my life history, my life stories? Like, why would I do that? Some people think it's the fees. Oh, it's too expensive. Lawyers in Nigeria charge exorbitant amount, and then like, just supposed to believe. But the most cogent reason why most people do not have their wills is because of the next of kin and beneficiary misconception. According to Clause 8B of the Pension Reform Act, it basically says that your beneficiaries cannot, access your retirement savings account or your pensions if there is no will or a letter of administration in the case of an intestacy, that is when you die without a will. So please do not let us think, oh, because I have a next of kin already written in my pension form with whatever institution, my beneficiary says, please, the Pension Reform Act clearly states that your beneficiaries will not be able to access your assets if, there is no will in place. And trust me, because of how slow the judicial system is, you do not want to go through the rigors and the pains of, having a letter of administration. So that's why it's very essential that we allay all our fears as to why we should not have a will, and then look at the benefits that we can give our beneficiaries if we have a will. And also, to draft a will, you need to understand that, there are certain elements, there are certain fundamentals that your will have. For example, you must be of sound mind. You must be of a very, very sound mind as at the point that you're drafting a will. And that is why, even the law depicts that if you're an old person and then there are possibilities of the sign of dementia or what have you, or, the sicknesses that come with old age, you would need a doctor to also assent to the fact that you were of sound mind when you drafted your will. Also, you need to appoint executors. Executors are the watchdogs of the will that would ensure that, wishes in your will are carried out according to how you stated it. Obviously, you need to have witnesses above the age of 18 that also witness to your will as at the time when you're signing. You need to also lodge your will at the probate registry. I cannot overemphasize the importance of lodging your will at the probate registry because it affords legality. It's in the case of any dispute, for example, if someone fraudulently brings a will and says you are the one that drafted it, having that will lodged at the probate registry give it every legal backing over any other will that comes. Then obviously you need to safekeep your will so that unknown persons that you've put in your will that are supposed to benefit from the assets won't even know that they are going to benefit because of the obvious reasons. You don't want to tell somebody that you're giving them all you have even before you leave. Then you can update your will as time goes on when there are important scenarios such as you having to change your executors or you having to change your beneficiaries. So we at Afrinvest Trustees, we have the classic will and we have the comprehensive will. The classic will basically is for individuals with modest size of estate. If you have just little asset, maybe like one or two real estate properties, few bank accounts, few investment accounts, the classic will is the product that we've developed to be able to cater for this need for you. Also, we have the comprehensive will. This comprehensive will is for actually people with more complex sizes of estates, people with more complex, affairs. And then let's say, for example, you have offshore assets, you have a lot of shares in companies, and then you're looking for a way by which you can divest and devolve all of these assets to your beneficiaries. The comprehensive will is actually the product that is best for you. And as you can see here, we've made our classic will also very, very affordable to the price of 60,000 naira, inclusive of all statutory charges, that is lodging it at the probate registry. Just like I said earlier, also, it can take 2 real estate properties. It can take, your cash in bank, your bank accounts, your other investments, and obviously the comprehensive will. Just like I said, also, this goes for a price of 250,000 naira or 1% of the assets, whichever is higher, as at the point by which we are helping you to put your estate plan in place and then putting your will in place. So definitely, I believe that with all I've said, before my colleague Achiso will be talking about the trust, there is a poll that is going to come up on. I just want you all to answer the poll as honest as you can. And at the end of the presentation, I would also be taking your questions and be looking at the answers to the poll. Chisom, thank you, please. Thank you.
Thank you so much, Ebo, and welcome again. So my name is Chisom, and I'll be taking the estate planning to Trust in Focus. And as we're also taking the poll that everyone has given, I would also like to also share a poll as well, just to know how many of us have an idea of what a trust is, as well as our age range, so that it would inform us. It will inform us today. So, what is a trust really? A trust is something that is also a part of an estate planning tool. It's a tool to use to plan your estates. Now, we've spoken a lot about the will, and if you look at this, you see that a trust is an all-encompassing structure. You can have a will in the trust, you can set up a foundation, you can have an incapacity solution, something like a power of attorney. You can also have a deed of gifts, which is a tool for you to start to think about, your beneficiaries, what happens to them while you're alive and even when you're no longer here. So in terms of what a trust is, it's a tripartite agreement. It's something you can call a legal agreement between you, the settlor, we like to call it the settlor, and who creates the trust. So you decide to create a trust and you say, okay, I want to think about succession plan, for example, because that is something that is very not really taken into consideration here in this side of the world. Well, what happens to my corporate entity that I set up? What happens to my business? You see that a lot of people they're big names in the past. They're called what we call old money and new money. You see, those people have some sort of limelight, but at the end of the day, in the next 4 or 5 years, and there's nothing to write home about such an estate. You see, people say the first generation to the second generation comes in, and it no longer becomes an estate of repute, and you start seeing that a lot of the assets have been mismanaged and been mishandled. So that's why setting up a trust is very, very important. And it is something to think about, because the settlor begins to put structures in place now that they're alive. And also, and the important thing is to include what you call a trustee, a corporate trustee like ours, like Afrinvest trustee, and to have your beneficiaries well known. So for a trust to actually be a well drawn out structure, there needs to be 3 certainties. One is the certainty of intention. There has to be an intention that you intend to create the trust, and certainty of subject. You have to own and actually own the assets that you intend to include in the trust. Now, there are different asset classes. You can have the liquid assets, you can have real estate, you can have jewelries, as mentioned earlier. And you say, I want to pass this on to the next generation. And I also want this next generation to be able to pass it on to the second, to the third, fourth generation. So now there's something that governs this structure. It's called a trust deed. And having this structure in place with a corporate trustee ensures that the trust deed and your intentions, as I said earlier, are carried out through and through. There would not be no mismanagement. There will be no going outside your intentions. Now, in terms of flexibility, that's one thing that a trust offers. You have the flexibility to see how it runs. If you feel that you're not happy with what is going on, you're not happy with how it's been structured, you can come back and say, I want to include, I want to exclude, or I want to change the whole structure in place to have other assets or to have other beneficiaries if that's your choice. So one other important thing, what does a trust, why a trust, why do you think of a trust? The confidentiality is key. A trust is something so confidential and so private between you and your trustee, to the point that it's only at the instance of maybe death, or maybe there's been a change in the family structure, that other people within the family might even know that a trust is set up. Now, if you're talking about a will, it's probated. You can just go to the public probate registry and you can pick up a will, but everyone knows Gani Farame's will. You can just do a Google search and you could even see it. But at the end of the day, if you have a trust setup, it's extremely private, extremely confidential, and flexible, as I mentioned in the past. It is seamless because it's set up. Yes, the trust deed. You have that conversation with your trustee, and you set it up, and it begins to run. It's extremely seamless. You have certain tax saving measures that it also provides. Now, we're not avoiding tax. You are just being tax effective. So, for example, if you have set up a trust and you're no longer here, and inevitable happens, your beneficiaries, enjoy the benefits of not having to pay estate taxes in terms of transfer of assets and etc. Now, asset protection is very key. Like I mentioned earlier, you have situations where people grown so big, big names, and then in the third or fourth generation, there is nothing to even pass on to the grandchildren or the grandkids, and all they have is a well-known name. So one thing that a trust would ensure is asset protection and succession, because it's one thing to have assets, it's another thing to have a plan in place to ensure that the beneficiaries know what's the intention of the settlor in terms of and making the businesses, the asset, real estate companies, as it were, to continue to be an ongoing concern. Now, you might be asking yourself, okay, so am I just talking about people who have some sort of tangible assets? Now, you can start, as I'm speaking to you, it doesn't matter whatever assets you think that you have. You can start now to start thinking about setting up structures in place, no matter how small. You can have something you call the living trust. Now, a living trust is, like I said, is one method where you can start to think about putting down written instructions for what happens now that you're alive and even when the inevitable happens. Now, you can give the trustees full discretionary on how to run this estate in accordance with the trust deed. According to the trust deed, you can have liquid assets in your trust. You can say, I want to start saving towards a particular goal. It could be the education of my kids. It could be for whatever reason you can start to have a trust. Now, the benefits is a lot of benefits to having these conversations. So you can have uninterrupted access to dividends. That's for the beneficiaries. Now, one of the disadvantages that you might have heard of having a will is that the process of getting grants of probate or letters of administration, like we said, is the legal system in Nigeria. But now you can have a benefit of having a trust, which is the beneficiaries have direct uninterrupted access. So we know the beneficiaries and they are known, and we also know if there are any issues that may occur within this structure. And that means that the beneficiaries will have direct access according to the trust deed. Now you can also use your trust, your living trust, to protect yourself against a spendthrift beneficiary. Like my colleague mentioned, that beneficiary in question is a beneficiary that you can see as having some sort of spendthrift attributes. Now you can have a trust set up that would protect yourself and protect your assets against such instances. So you can also use it as a retirement plan. You can start today, as I mentioned, no matter where you are in terms of accumulation of your wealth. If you're just on the stage of growing your wealth, you can start today to start thinking about saving and a retirement plan in a trust. And you can, it's, like I said, it's flexible. You can use it to give gifts to your beneficiaries. You can terminate it at any time. And obviously within, if the trust, the whole entire idea of the trust has been fulfilled. Now, you can also have a testamentary trust, which you've mentioned, which is something like a will, but it's a trust in the sense that it will be drafted in the likes of a trust, but it will still be probated. Now, no two clients are alike, no two individuals are alike. Your assets are different and your needs are different. So that's why it's very key to have a corporate trustee and speak to corporate professionals so that they can guide you on your path in terms of what works for you as an individual and what your future plans are. So I just want to see what our poll has been like so far. So we have 66% of people know what the trust is and 34% don't, which is very interesting to note. Now, it's one thing to have an idea of what a will or a trust is, but do you have one? Have you created one? Even if you have one, when was the last time you had a conversation with your family? Because things change. So these are the kinds of conversations that we're having. So I know that I'm speaking to a large number of people within the age range of 36 to 55, which is an age of more of accumulation. So you have a lot, you've spent time, and you should be looking at accumulating a few assets, or you already have assets here and there. So now is the perfect time to have this conversation. Do I have a will, or do I have a trust? So with this, I'm going to be handing over to my colleague, Yewale Lenikon, to take over and just give us a recap of what we've said so far and talk about other services that we offer in Afrinvest Trustees. Thank you so much.
Thank you very much, Isa. And good morning, everybody. A recap of what my colleagues have actually said the past 40 minutes. Having a will or setting up a will and planning our estates cannot be overemphasized. A lot of issues, a lot of agonies, a lot of pain have come as a result of individuals not putting their houses in order. A very clear example is a former federal minister of finance in this country who was killed in 1966 during the 1966 coup. And his children and relatives fought over his assets. He was a very wealthy man in his time, and he had so much assets. And his beneficiaries fought to the extent that for about 50 years, they were in court until the Supreme Court gave a judgment. Even at that, some of the kids had even passed on. It was a terrible one. And you can juxtapose it with that of Chief Ganifa Emi. Yes, you can say that at a time somebody came out and said she had a child for Chief, but the truth was that Chief emphasized that a lot of things could happen when I'm gone. And the first thing he did was, look, when I'm gone, shut down the chambers, shut down the printing press. But the truth of the matter is that when you juxtapose the two cases, you notice that one man prepared for his demise, and the other person, well, didn't know he was going to die at that particular time, but he had started acquiring assets. And what we normally advise people is that you don't have to wait till when you are 50. You don't have to wait till when you are 60. Like the poll we just took now, we discovered that there's an age bracket, 35 to 55. And like my colleague said, this is the age bracket when you begin to acquire assets. Immediately you start to acquire assets, you need to give your lawyers instruction. You need to give your trustee instruction that, okay, I need to put my assets in a will. I need to put my assets in a trust. The essence of having a trust, the essence of having a will is very key. I mean, like my colleague Rita explained earlier, Kobe Bryant, the legendary basketballer, fine, he had a trust, but for reasons best known to him, he did not include his last child. She was not noted in his trust. And like we advise people, immediately there's a change in your status, there's a change in your circumstance, you instruct your lawyer or your trustee. I mean, that's where the codicil, they make an amendment that, okay, include this child, or I've just acquired this asset, let it be included in this will. So part of our services as your trustee includes drafting your will. I mean, which I stated earlier. I mean, we're all lawyers here, and it will be better when you give us the instruction to write your will on your behalf. Living trust, Chisom has really given a good background on living trust. It's preferable to a will because you don't even need to go and register it in probate. You avoid that aspect, and it's you doing your thing while it takes effect from your life, not like the will that takes effect from demise. Education trust, it's always advisable that immediately we have kids, you begin to prepare towards their education, right from the nursery school down to the university. Power of attorney, we also render that service. Letter of administration, this is a major one, and it's always a big issue when the settlor or the testator passes on. Then corporate executorship services. Now, these are the services that we render in Africa, Afrinvest Trustees. All these services are services that if you knock on our door or you send us an email, which will be shown on the screen, anytime we will get across to you. We will take your instruction, and we look forward to hearing from you. Our phone numbers and email addresses are stated on the screen here. That's of Rita, myself, Chisom, Ebu, and Damilare. And our corporate head office is on 27 Gerard Road, Ikoyi. We also have our office in Abuja, Port Harcourt, and we just newly opened our office in Onitsha. So we look forward to taking your instructions. We look forward to acting as your corporate trustees in your estate planning, either drafting a will for you or drafting, setting up a living trust for you. Thank you, everybody, and we would appreciate questions. I think there are some questions in the chat room. We will respond to. I think the questions are being responded to. Rita, please, can you come on?
Yes, okay, thank you everyone, and thank you for the wonderful presentation by all. Thanks, Chisom, thank you, Ebolo, and thank you, Oyewale. So we have some questions in the Q&A box, and we also have some in the chat room. So Chisom and Ebon would champion that, and they would answer your questions as best as we can. I think we have just a short window. We intend to shut this down by 12. So as many questions we can answer before then, we will answer them. Otherwise, we'll send them out with the answers after this presentation to everyone. Thank you. All right, Chisom, thank you. Over to you.
Okay, thank you so much, Rita. So I'm just going to be taking questions that are for trust, then my colleague here will take for wills. So I have a few questions here. One says, does the trust offer any tax advantages for beneficiaries, residents or with dual citizenship abroad? In some countries, residents and citizens are taxed on worldwide income. Okay, for us, our jurisdiction is Nigeria. And if you have certain assets or you're setting up the trust in Nigeria, now the trust can also cover for assets that are outside of our jurisdiction. However, but in terms of execution, that is when it becomes a different process altogether. Now, if the assets are abroad, it means that we would have to be in some sort of partnership or collaboration with legals or a legal person in that city or in that state where you are, which has assist us in terms of execution and ensuring that there is a seamless transfer to your beneficiaries. Now, in terms of tax advantages, it's different in a lot of jurisdictions, but for us here, we're speaking in terms of tax management and tax effectiveness, and more like being smart when thinking about your beneficiaries and the fees that they might incur when it's time for estates, when the estate is being executed and the like. So that is how to handle such situations. So I think I have another question here. Okay, so how does the trustee know when you're no longer there and the trustee is to take over? Please explain how a testamentary trust is incorporated in the will. So how we know that our settlor is no longer there. Like I mentioned, a trust is a very, very private and confidential structure in place. I like to say that we as trustees know you even better than your lawyer, in some cases better than your family members. So we are always with you. Setting up a trust is like setting up a clone of yourself. So we as trustees, our fiduciary relationship extends to you, your beneficiaries. We know what's going on with you. We also engage you quarterly to start thinking about making some changes, or if there are any huge life changes that's happened within a certain space, maybe marriage, new family member coming in, etc. These are conversations we have every time with our clients. So we know if there are issues, and that's when we then take in and come in to execute. So in explaining how a testamentary trust is incorporated in a will, is a testamentary trust is drafted in the likes of a will, and it carries on just the way a will would be if at the end of the settlor's death. So a testamentary trust will be probated, so it would have to be probated just like a will. But the difference is all the assets now reverse to the trustee, as opposed to when you have a simple will or a normal will, so to speak, the assets are distributed. But in terms of a testamentary trust, the asset goes to the trustee, and then the trustee now starts to distribute to the beneficiaries, which ensures more management, more effective process, and no issues among the beneficiaries. I don't know if I have any. So Ebon, I think maybe we should take yours, so in case I see more, then we can go on.
Yes, thank you very much, Chisom. So I will just be taking a couple of questions from the will aspect. I'm seeing quite a lot of interesting questions, actually. And but before I take some of the questions, I also just like, if for us to see the poll that I asked of, and then if we know about wills, as you can see, we have 59% saying that they've at some point considered a will as an estate plan, and we have 41% saying they've not. This number is still quite relatively low because, just like I said, a will is a very important document, and as much as a trust complements a will, if you have your retirement savings account, which happens to be one of the most sizable assets that we have, you would not be able to transfer those assets, those monies in your retirement savings account without a will. So please, it would be very, very, very encouraging if in our next document, I ask this question again, and then we see a huge rise in numbers. So I'm going straight to the questions, basically. So a question says, should the executors of a will be lawyers or just anyone you choose as executor? So the executors of your will need not be lawyers. So by law, it states that a minimum of 2 persons, maximum of 4 persons can be the executors of the will. However, if you want a corporate organization, a corporate entity to administer or to be the executors of the will, then you can appoint only one corporate establishment or corporate institution. Another interesting question says, if you have a will outside Nigeria, is it also effective in Nigeria? If not, how can it be effective in Nigeria? That's a very brilliant question, because in as much as a will is a widely recognized legal document worldwide, for the instructions that you've made when you were in the UK, or the US, or in another jurisdiction where you lost your will, if you want to distribute some of those assets that you have in your home country, for example, if you are a Nigerian, you would have to reseal or register that will that you've already drafted in another jurisdiction, also in Nigeria, so that the courts in Nigeria can recognize that particular will as being legal to be able to distribute the assets you have in Nigeria. So yes and yes, a will drafted anywhere in the country can apply in another country as far as it is registered in the country where you want to dissolve such assets. Another interesting question says, why the need for a next of kin on official documents when they do not have access to any of your estates in your demise, and what are their roles? So basically, just like I said, and I like this question because it shows that we've been following. Next of kin is basically a contact person, for any of your business, for anything. I mean, we see next of kin information on almost all the documents that we have. So that next of kin is basically the person that should be your contact person in case you are unreachable, in case you are not being able to be reached. And that's why it is very important for us to have a will, so that we can include our beneficiaries that we want to enjoy from our estates. Also, another interesting question says, are there extra costs if amendments are to be made to your will or a trust? Yes, this question is twofold. It's talking about the will and the trust. But in regards to a will, yes, there is an extra cost, but it will be most likely, let's say, half or lower than, but definitely lower than the initial cost that you would have done if, for example, you drafted your will Afrinvest and then you want to do a codicil or you want to make an amendment to your will. Yes, there's an extra cost, but it is either, it's definitely not going to be more than half of the original price for which it will take to draft a will. And this also goes to trust. If you want to do a supplementary trust where you have to make a significant change, maybe to a beneficiary or to the protector of your trust, what have you, it also comes at a cost which definitely would not be more than half of what it would have cost you to draft off your initial estate plan. Over to you, Chisom.
Okay, thank you, Ebun. So I have one question here I want to just start with. You said the living trust does not require registration in the court. How is it legalized? Like I mentioned, the trust deed is a legal document. There are three, is a tripartite agreement, and it's legalized because it's between you, the settlor, us, and us, the trustee. Now, that document is a legal document. So it is very legal, and it doesn't need registration in court for a document to be legalized. As long as there's acceptance, there's consideration, it becomes a legal document. Now, there's another question here. It says the fee that is charged by trustee, is it a one-time fee or recurrent fee? Now, our fees are in different ways. We have the setup fee and we have the annual management fee. So an annual management fee occurs annually, which is usually on the anniversary of the trust. And the one-time fee is to set up, take your instructions, and then the other fees that might come in, which is administrative fees. But our fees are very negotiable. And like I said earlier, there are no two clients are alike. So assets were very value-based. So based on the value of work that we're going to be doing, our fees are structured to cover for that. Okay, Ebo, I think there's one more.
All right, thank you, Chisom. So there are a lot of interesting questions also. So another one says, okay, although it talks about the trust, but let me quickly take it. It says, you said the living trust does not require registration in the court. How is it legalized? That's a very brilliant question. The living trust, yes, it does not require you to register it in the court or like approve it, but the trust comes with a trust deed. It is a document that governs your relationship with us, the trustees. And this trust deed is to be stamped at the Federal Inland Surface Revenue, the FIRS, for validity, so that, in the course of you having to probably use the document to make any claims or to do any other activity incidental to what the trust is, it has a legal backing. So yes, in as much as you do not register it in the court, it is very, very important for your trust deed to be stamped after you have constituted your trust deed in the process of, yes, completing your trust, setting up an estate plan of the trust with us, your trustees. And another brilliant question says, how does one tackle the inclusion of a retirement fund in a foreign country? So unfortunately, Nigeria cannot, jump into the arena of another foreign country and then, ask for or repatriate the retirement fund of a foreign country. So definitely every country, every jurisdiction, they have, their own pension laws. They have the ways by which all their retirement funds are being calculated in the way that such persons, their beneficiaries, can access the fund. So the best way for you to repatriate your retirement funds from a foreign country is when you've been able to accumulate such funds in cash, you can then open a trust here in Nigeria, put that funds in cash in the trust, and then invariably the funds that are in your trust can then transfer down to your beneficiaries, including yourself, as you also can be a beneficiary to your trust. And also you can choose to put such funds in your bank account, put such account balances in your will, and also transfer that particular asset to your beneficiaries. So in as much as you cannot directly, say that the retirement funds in a foreign country, Nigerian law should be applicable to you, there are ways by which you can also make sure that those funds, get through to your beneficiaries here in Nigeria. So I think for now, those are the questions that we'll be able to take. Definitely, there's still a lot of questions coming in, but be rest assured that we're going to answer all your questions. We are going to reach out to you personally, and we'll do our best in, helping you set up your estate plan and helping you secure the future of your loved ones. Thank you. Yes, please.
Okay. Thank you, Ebon, and thank you, Chisom, for the brilliant ways you've answered the questions, and thank you everyone that has asked questions. Like Ebon said, we're still available to answer some of your questions, so you could still turn them in. We'll display their email addresses, so you could send it to our email addresses, and we will do our best to answer them. Would also answer these questions and send a link of the answers to the questions via your emails. But just to reiterate something Chisom said on the fees. So she gave a breakdown of fees for the trust. However, for wills, the fees are one-off. So if you want to draft your wills, our charges there are one-off. However, if you also want to do like an amendment to your will or update your trust, those also come with fees. Like Ebon said, they are not as much as what you pay originally, but those additional fees are also one-off. I think I saw a question on comprehensive will asking who values the assets. So we would appoint an independent valuer to value the assets and then charge a percentage of that valuation as a fee. So the evaluation is not done by the trustee, will be done by an independent valuer. Unfortunately, that's the much we can take for now. We want to thank every one of you for taking out time to attend this webinar. We hope that we'll have you've taken something out of this webinar. You'll be more informed about what an estate plan is and actually take steps to also plan your estate now. So we'll send out the presentation, we'll send out hopefully the recording and the answers to the questions that has been asked. And even if there are more, we'll do our best, like I said, to answer them and send the answers down to everyone. So thank you very much once again. Thank you to the panelists. Thank you to our audience. And we hope to see you next time when we have another series, webinar series. Enjoy the rest of your day, everyone. Thank you.